This call is exclusively for our premium members or anyone that we might share the recording with later. In fact, some of this material we are going to share more broadly because it's important, because it's sort of a broad subject tonight, and it affects a lot of people. So we thank you all for being here. Now I like to start every call with a brief prayer because I think it's just a good thing to do to get protection over what we're doing, because we do tend to come under a lot of attack these days for speaking under the guise of free speech, and we need to let the world know that that's got to stop. And so anyway, that's how I like to get started. Join in if you like. In the name of the Father, Son, and the Holy Spirit. Lord, thank you for all the blessings and the opportunity to be together. We know we're two or more together. You're there with us. So today we're going to be sharing thoughts and ideas about how to protect ourselves in this legalistic world that we're in. We thank you for the guidance, the tools you've given us over the years, primarily that guide that we call the Bible, that gives us a whole lot of legal reference that has led into and has formed our legal system. Whether people like that or not, it's just a fact of life. Even the Supreme Court has acknowledged, and we thank you for giving us that wisdom and knowledge to share openly. So again, thank you for that. In Jesus' name we pray. Amen. Legal disclaimer, we're not attorneys. I'm not a practicing attorney. I cannot come in and represent you and jump in and help you do your case, because there's just too many of you and too many cases. So all I can do is teach you on a broad scale how to do these things. And really, I'm not telling you how to do it, but we really are here to guide you on how you do it. Because ultimately, one thing the courts don't like is somebody who's well-equipped that goes into court themselves. Or if you've got an attorney, you're directing them correctly in a way where you're still in control, and you can do that. A lot of people think because you get an attorney that they'll bully you into everything, and sometimes they do. They need to know, though, that if you hired them, you're the boss. And you need to be the one directing things. You'd be surprised how sometimes they don't even know some of the things we're going to talk about. Or if they know it, they don't use it very effectively. So the idea is that you become the one with the knowledge, you become the one directing things, because whether you think you have a legal problem or not, every second you walk out the front door or pick up the phone or file a form or pay a bill or not pay a bill or get married or not pay child support or any number of things, you're dealing with the law all the time. Why this is not part of our fundamental education system? Well, I don't want to say I don't know why. I know why, because the Bible says we perish for a lack of knowledge, and woe to you lawyers, for you've taken away the keys of knowledge. The legal system is designed to keep us ignorant and stupid. And it doesn't like it when we wake up and we actually have knowledge of what we're doing. We have a clue as to what we're doing, because we have a right and actually a duty to know something about the law. Now, I know they make it sound big and complex and difficult. And it kind of is, because it does take some work. But then again, we perish for our lack of knowledge. So if you want to perish, do nothing. But don't wait till it's too late to start learning. A lot of people show up here as a member when things are kind of a little bit late in the game, and we cannot, I can't go back in time and correct the mistakes. If you do something we tell you not to do, and then you come back and say, well, what do I do now? I'll say, do what I told you to do originally and don't do it. I mean, I cannot tell you how to fix what we told you how to fix before you did it. And hopefully there are some things you can correct, and yes, there are things you can do to rescind what you've done, but it's more difficult when you do it that way. It's hard to pull water that's already passed under the bridge back, okay? And I can't do that. I'm not God. I can't move heaven and earth for you, you know. You have to be able to do these things yourself. So the reason is what we do is to get people to be prepared. Even if you maybe just manage to get through a situation you have now, but in the future, gain more control over situations, whether it be contracts or a marriage contract, a filing over something, dealing with the debts, dealing with a criminal case, a traffic ticket, whatever it is. We're not here to tell you exactly every legal detail about what to do. We try to help you have an understanding of the philosophy of how you approach these things. And then you come up with the answers, because the answers are right there in front of you. They're available, especially today. We have the internet. We have the most powerful tool in the world when it comes to legal stuff to help you do it better. You have Google Scholar to do case law search, because if you go into court without some case law, expecting to win, you will lose. Just telling you now. Sorry, you got to learn a little bit about how to find some case law. If you don't know the rules, well, guess what? You're going to have problems. So we're going to get into the rules here in a minute. I want to talk about rules quite a bit today, because I'm going to admit it, I'm a football fan. I don't watch it all the time, but there's certain things I follow. And one thing I know about the game is if you don't know the rules, sometimes you'll make strategic mistakes that are going to cost you a game. In court, it might cost you your case. All right? And so you have got to know something about rules. So we're going to cover that tonight. Just a reminder of a few things that we have as tools for you as premium members. If you're a member of our website, of course, we have the free membership level, which gives you a basic overview of what we do. But when you become a premium member, you get a lot more information. But just so you know, of course, if you ever need support regarding your accounts, your monthly payments, any of those kind of things, don't email. Go to the support page, yourlaw.org/support, and of course there is a link to it right there on the website if you ever need it. Okay, I'm going to go over to the website here. Just go to account support. Really hard to fit, it's kind of obvious. On your phone, it might show up as the little 3 lines. You've got to click on that to pull these menus down. But, you don't know the terms and conditions when you signed up. There are your terms and conditions. You want to get to the various member pages you might have access to. Some of these you will not have access to because you're seeing on my screen certain private coaching pages that are only available if you're in those programs. Okay? You want to do some upgrade to one of our coaching programs, status and wealth coaching, equity discharge class, criminal case strategy coaching. Those are private coaching options that are in addition to the premium membership. Forum discussion area, lots of information here. But not everything is open. Excuse me. Not everything is open to all. These are the areas open to premium members, but if you go down to equity class and some of these other specialized areas, they may not be available to you because you're not part of those classes. But you have a lot of access to a lot of information just on these premium member discussions. Okay. Plus, we have a Telegram group, the Telegram app. That's where most of the communications and activity happen. So just to remind you what's on the page. I get a lot of questions. People, it's like they're not even clicking here and looking at the menus to see how do I get to the premium member page. Well, there you go. You got to try it. How do I see the video replays? Well, there you go. It says right there on the screen. How do I ask my AI bot? If you're a premium member, you can ask the AI bot questions. I've had people have some really interesting interactions with our artificial intelligence bot that's installed on our site. Again, you only have that if you're a premium member. Okay, access to that page. So lots of stuff to go through. You have a ton of information. Important tools you might want to have in addition to having a membership. There's joining and upgrading options. Just go to /join. If you want to get the How to Win in Court course, which we reference a lot, if you want everybody really to study that, consider those techniques. And it'll teach you procedures, which we're going to get into tonight. /JD is just the link to get directly to get that optional course. It's a small extra fee, but it's well worth it. Less than a half hour of attorney time, and you'll know as much as most attorneys know, but you'll know more about a lot of them and how to win. Direct access to the premium member page is /PM. I'm showing this to you on screen if those of you who are watching. Equity class, if you want to learn about how to enroll in the equity class, it's Equity Enroll. We're currently in our second week of the current class, which is a 12-week class. We don't announce very far in advance when we're going to do one of these, maybe a month or two out. Sometimes we choose to take time off, or we may never do it again. I can never predict whether an instructor or I will be available to do another 12-week session. So you can still enroll. You'd have to catch up a couple classes, but pretty much we're just closing out that current class right now. Get information on that on the Equity Enroll page. The trust and status coaching, we do status, we don't do status correction because that's not really a thing. It's not really a real thing. I know it's taught on the internet a lot. Reality is it's about modifying your contract. And so we teach you how to approach it that way, how to go into some of the contracts you have now, passports, driver's license, Social Security, change the contract a little bit so you limit your liability. But you don't want to get rid of all those things. We're not one of those people say, get rid of your birth certificate or something. It doesn't do you any good. We live in a moneyless society with no real value currency. You have to understand how the system works, though, and you can navigate it better and create better wealth and protect your assets. That's our approach to it. You can't truly operate in the private until you, for example, have a true private trust. And I'm not talking about most of the ones you see out there. And a trust is not something just because you call it a common law trust or just because you call it an irrevocable trust. That doesn't mean anything. The name of it means nothing. It's the writing of the trust matters. How it's organized and structured and ran is what makes it a trust. So we teach you the in-depth knowledge about how to do that kind of stuff. Plus, it can dramatically affect your tax bills and your liabilities and how well your assets are protected. It doesn't work well after the fire is started. This is more for planning going forward. Equity class is dealing with something that comes at you right now and you've got to deal with it. So that's the difference between equity class and trust and status coaching. They both are important, but one's more planning, one is more dealing with a current urgent issue. If you're in a no victim criminal case, there's really no solid victim, they really don't have a great case, then look at our criminal case program called Slam Dunk, /Slam Dunk. I've already talked about the forums. You need to communicate with us on the premium member page. It tells you how to reach us on Telegram or directly or through telegram.org, how to join our groups that are available. There is a free and premium member group now. Many of you may already be a member of that. And then each of the coaching groups has a private group for different types of coaching, whether it's Slam Dunk or criminal case, private trusts, equity, and that sort of things. They have their own groups that are private and by invitation only if you're in those coaching programs. Make sure, so many people go, well, where do I find the downloads? Where do I find this document, that document? Well, you go to the premium member page and you click you go find the link that says downloads. I know this is kind of obvious, but you'd be surprised people don't bother looking. You go to the premium member page and you go down here where it says there's the meeting announcement for this week. Here's the downloads and tools and documents. These are all folders you go through. You can't search these folders and find them via our search engine. It doesn't work that way. These are all in separate folders off the website somewhere, so they won't search very well. But you can click each one of these, open them up, read the documents, and see what they're about. There's different subjects here a lot of people ask about, from subrogation expressing the trust, credit collections. The Start Here folder has a ton of really important stuff. In fact, it has one of the documents I'm going to show you tonight. Mortgage information, basics on dealing with mortgages. And by the way, let me tell you this about mortgages. Don't screw around with your house unless you really know what you're doing, and it's really hard to win even if you do. So just keep that in mind. Don't screw around with your mortgage. You're better off accelerating the payments with some techniques we show you than going in there and messing around with maybe losing your house. So be very careful there. How to do notices and complaints, references, tax laws, exemptions, status in court, introductory information. It doesn't go into the same depth as our full status course does, but it does give you an introduction to it. Traffic matters, all kinds of tools on dealing with speeding tickets and that kind of stuff. And dealing with public officials, bonds, and that sort of thing. There's, again, lots of good information and downloads there. There's a bunch of courses included with your membership. Look through the titles here to see one that maybe fits what you're looking for, okay? All right. Let's see. And then we get into if you're in some of the private coaching programs, these shortcuts get you access to special pages. Now, these may not go to a page that you have access to if you have not enrolled in these private coaching options. This is just for a general reference. If you're in those programs, you want to find the tabs to those. That's one way to get there. And of course, always use the menus, member areas, and you'll find links there that pop up as well, depending on which level you're at. If you're not at that level, you won't see it. All right? There's a shortcut to our AI page where you can have kind of ask more legal questions. By the way, these questions may not come out the same way I would tell you to do something because it can't read my mind, but it can give you general legal procedural information that's out there. And always, always, always with any artificial intelligence tool, go double verify the answer. Go find another source and verify it, okay? Because sometimes AI doesn't get it 100% right, but it might lead you in the right direction. So those are just some of the things that you'll have access to. Here's how to win in court without a lawyer, the link to that. We have a link to it, so please use our link. And how to reach us and communicate with us and so forth. So a lot of stuff that's on the premium member page. Get familiar with everything there. There's a lot there. People say, oh, there's so much to go through. Well, it's better than the alternative. And it is really referenced because we don't know where you're at, where you're starting. So we just try to give you all the tools we can. All right. So for tonight's lesson that we're going to get into, we're going to talk about the lessons tonight really are going to be about the rules of evidence, rules of procedure, why they're so important. If you have a factual case, you'll need the How to Win in Court Without a Lawyer course if you're going to really go in depth on this stuff tonight. That's urlaw.org/JD. You have to understand, and to really learn that course, if you really want to zero in on what you've got to focus on, is procedures, rules, and elements. Now, if you know what an element is, elements are the elements of a given charge. Let's say you're charged with money laundering. Well, if you go look up the charge, and they'll have a statute, you look up the statute, and you look for the elements required to convict. If you don't know what that is, and you've been in your case more than an hour, and you haven't looked that up to really understand what is it they have to prove, what are the elements required to prove, then you're going to get all over the place. You're going to get lost. You're not going to really focus in on the things that matter to win. If your objective is to win your case, well, if you look at the elements required, and you look at it and go, my gosh, they've got all three elements, then you're probably going to lose. Simple matter of fact. Now, this applies whether it's civil or criminal. A criminal, of course, means something you could go to jail for. Civil is something you could get financial charges for. Okay? But if let's say that you owe a credit card, and the law says, well, for them to win a credit card case, and whatever they're citing is the violation, then the elements required are, well, if you don't know the answer to that, all the elements required, you cannot win. I'm just telling you, this is where the rubber meets the road. If you don't know the elements required for them to win, or for you to win, you lose. And when it comes to the elements, I'm kind of going to this first because it leads to the others. But when it comes to the elements, if you know that they are lacking any one of the elements required, in most cases, it'll say it requires all three, or all four, or two, whatever elements it says are required. And if it says they must all be proven, not some, but all, careful, watch the words, see, some versus all, or versus and, then if they have to prove all three elements and they're missing one, that's what you zero in on, bringing out in the case. If they're coming after you for something, a criminal charge or a civil charge, and they're missing some of the elements, that's what you want to expose. That's your whole goal of your case, is to expose the missing elements, then do motions to move the case to expose what's missing. And there's various ways you do that. You do that through motions. You might do it through discovery, where you ask for certain things. You might do interrogatories, where you get to literally interrogate them over it and get them to admit or deny things. In other words, you create and build a record before you ever go to court. And if you're not doing those things, you just say, oh, court's coming, what do I do? It shows me you haven't studied the elements and you haven't studied the procedures. And you know what? This takes some work sometimes. Sometimes it takes a lot of work. But if you know the elements and you know they've got a defect in their case, defects, then that's what you can zero in on to give yourself the best chance to win. Is it guaranteed? Sorry, nothing in life is guaranteed, especially when it comes to court. But when they see that you get what elements are, and then you can use the procedures to show that, you'll get the respect of the judge, and you might just get the other side to throw you a deal. Sometimes, let's face it, sometimes we do things to get ourselves into a problem. You know, maybe you really were driving really too fast, or you did marry that person. Now you got to deal with child support. Well, you got yourself into it. You got to deal with it. Maybe you didn't marry him, but you had intercourse. That's technically a contract. Because there's a duty and an obligation that goes with it, like it or not. It's not a religious issue. It's just a standard common sense issue. Everything is contract. Look at everything through a set of contract eyes. Do they have the elements of the contract required to win their case, or do I have it? If I'm trying to sue them, if I'm in a lawsuit, I'm trying to win. I've got to prove elements. I can't just sue because somebody said, "Oh, sue them for." Title 18, 1983 or something like that. Whatever it is you're basing it upon, well, you just don't sue based upon a statute or the title. You have to prove, if you're suing, you're the plaintiff, you have to prove those things. And if you go forward and you file the suit and you can't prove those things, it can really backfire on you. It could cost you money. You could end up paying their legal fees. So don't be stupid. You got to know the elements. And then you got to know the procedures to bring those elements out. So tonight we're focusing on what this course, url.org/JD, that's an optional course, but I recommend everybody own it. But I'm giving you, kind of telling you what it teaches, but it goes into much more detail than I can go into tonight, okay? So being a premium member, we talk about these things. That course is just a guide to help you go through it all on your own time. And then if you understand how to focus in on the elements required, either for you to win if you're a plaintiff, or if you're a defendant, for the other side to win, or that you can prove that they're missing. Sometimes it's only 2 or 3 things you've got to focus in on. Not the whole thing. Oh, he said, she said, and we argued about this, and she said that. I don't really care about all that. What I want to know is what can you prove with evidence, and not just evidence, and here's an important one. I'm going to type it on the screen. It's so important. Admissible evidence. Hope I'm spelling it right because it's not spell checking for me. But if you don't have admissible evidence to prove the elements, or they don't have admissible evidence. Now, you say, wait a minute, why are you saying admissible evidence versus just evidence? Because a pile of papers is not evidence. It has to be admitted. And your job is to keep their evidence out, and their job is to keep your evidence out. People will go, well, they objected. They motioned to dismiss. They objected, and I got this. It's not fair. They kept my evidence out because you weren't prepared for the fact that that's what their main game is, to keep evidence out. Why? Because if that evidence isn't, they may have the evidence, but if it's made not admissible, it can't be used to prove one of the elements required for them to win, or if you're trying to win and you're the plaintiff, for you to win. You see, the rules work both ways, just like in football. Both teams have to play by the rules. If you're on offense, you've got to do certain things. If you're on defense, you've got to do certain things. And, but it comes down to the same rules are followed. And this in court, it's what is admissible evidence. Boy, if you want to learn 2 important words tonight, admissible evidence, it's not really 2, it's 2 words, and then elements required. You just zero in on that before you ever ask me or anybody a question. But bring that out first. Find out, what evidence do they have? And is it admissible? And can I object to it and keep it out? Or if you're going after them, do you have admissible evidence? And it doesn't help prove the elements required. See how those 2 work together? Elements and admissible evidence? Yeah. And then can you get it in? Or can you keep it out? Depending on what you're trying to do, right? So that's the game. Now, how do you get there? Well, you're looking for defects in their case, and they're looking for defects in your case. And they'll use certain things called motions and memorandums and case law to prove the defect, because some appeals court, by the way, when we do case law has to do with appeals courts. In other words, what have the appellate courts decided in a dispute over this kind of an issue, on the similar issue, on similar facts? What have they said? And you can use Google Scholar. Type up Google Scholar. On Westlaw is another one you can pay for case law search. But Google Scholar is a good place to start and learn how to use it. But you're not just looking up for cases. You're looking for appeals cases where the similar issue you're bringing up exists, and then what did they rule? Did they rule in favor of the argument you're making or against you, kind of in a similar scenario? Okay, so you got to know case law, how to get it. You got to look for defects in evidence, so the other party doesn't have admissible evidence to prove the elements required if they're coming after you. And vice versa. They're going to do the same thing to you, offense and defense. All right? So when you know this, forget all this sovereign patriot theory stuff for a minute. Just talk about if you're going into court. First of all, rule number one is avoid going to court if possible. Avoid going to court. If you can do a lot of this before court or show the other side that they're missing something or you've got something or they've procedurally done something wrong, then you can get the case dismissed before court. But you just don't go in there saying, I challenge jurisdiction. They're going to say, and fill in the blank? What are you challenging? What evidence do you have that gives you the right to say there's no jurisdiction if they claim there is? You might have to prove something. Another rule I try to follow is this. I'm going to add this to the list here. Hopefully it'll show up. Is burden of proof. I use this a lot because it happens in daily life. People ask me questions. Well, you said this and you said that. I said I never say, oh no, I didn't. I say, oh really? Well, prove that I don't. I put the burden of proof on the other party in every argument I ever have. And I'll say, hey, maybe I agree with you, but if you can prove it. That usually shuts down arguments really fast because people say things emotionally without any proof at all. Let's say that your ex-spouse says you did X, Y, and Z, and then they go to the police and they report it, and they come and arrest you over it. Okay, cool, man, no problem. Can you prove it? I want to see the admissible evidence that is true, or I'm going to move the court to dismiss this. And once the other side knows you can do this intelligently, using logic and reason like this is all about logic and reason. If you can come at it without getting too emotional about it, say, sure, maybe I did, but before we say I did, can you prove it with admissible evidence that meets the elements required to convict me for that or to take my kids away? Then I have to go look at case law. I got to look at the statute. What are the required elements? Wait a minute, they don't have the elements. Well, guess what? Now you got a case. And that's how you have to approach it. You don't talk about what happened to me and woe is me and we hate each other and that kind of stuff. You have to get down to these simple facts. What can they prove? What can you prove if you have to prove? If you're falsely accused of something, then you need to break it down to these little parts. And if you can do this little exercise here, you'll be able to do a lot of this yourself. At the very least, if you have an attorney, you'll say, I looked at the elements. I don't think they have admissible evidence. There's this, here's a defect here. You got to sometimes help your attorney discover this stuff if you have an attorney, or do it yourself. You'll be able to do it yourself if you follow that course, how to win in court without a lawyer. So let me give you an example of just some things you can look up. And I'm going to talk about just rules of evidence, rules of procedure. You can also go to Google Scholar and that sort of thing, right? But I'm not going to get into that because that's a whole course all by itself. I've actually done videos on it, on how to just dig up some case law. But you got to find something similar to your case and see if you can find cases not too old. We don't go back to 1863, some act or some statute from 1863, because there may be a bunch of case law on that since then. So you go off the case law, not the original Supreme Court case or something. You go off how has the case law used that case and succeeded. That's really important. In other words, you don't just go off of the 1863, whatever versus whatever. You find case law recently that referenced it, and then the courts used that, and the appeals court used it, and it was successful. Okay, courts will look at recent cases in their jurisdiction. So, for example, let's say you're in the federal courts. Well, you think, well, I can use an appeals court case from the East Coast, but I live on the West Coast, a different district, they call them. Well, you can, but it's much weaker. It's much stronger if you're on the West, where we have the Ninth Circuit. We use Ninth Circuit appeals cases for our case law. Way better. Because you know what? That's like their boss, the judge's boss, speaking to them, telling them what they're supposed to do in this situation and what the appeals courts have ruled. If you can find out what the appeals courts have ruled and bring that in, and it's the boss of the judge you're talking to, which one do you think is going to speak louder? You saying that you glow in the dark as a patriot, or their boss? Which one do you think the judge is going to pay attention to? Which one is going to compel the judge to rule in your favor? Case laws from the circuit that they're in. If it's federal. If it's state, then you go to the state Supreme Court for that given state. It's California's state case. And by the way, know that obviously there's a difference between a case that's in a state court versus a federal court. Even though the federal court is in your state, it's not a state case. It's a federal case. It's a federal statute versus a state statute. So always break it down to what you're dealing with. Is it a state case? Do I need to look at state Supreme Court rules and laws and so forth? Now I'm going to show you here in a minute, for example, if you guys cut out this diagram and type this up, take notes. I hope you're taking notes. So I got kids screaming next door. These are the most important things you need to learn. So let's go to the rules of evidence, for example, and procedure. Okay. Now, I will tell you that most states use the federal rules of evidence. And although the states will have their own rules of evidence, so you need to go find your local state rules of evidence for the state of Oregon or Wisconsin or whatever you're in, and look those up as well. But the federal rules of evidence are a very good starting point to learn rules of evidence. Okay? And look, it's broken down subject by subject for you here. Yeah, it'll take you a little time to get through all this. You don't really need to know everything, but you definitely need to know things like what's hearsay. In other words, what's testimony that shouldn't be in evidence? How can you get it kicked out? You want their job is to keep your evidence out and your witnesses out, and your job is to keep theirs out and discredit their witnesses. Well, guess what? This tells you more or less how to do it. What's an expert opinion? When is it allowed? This goes through witnesses, competency tests, oath or affirmation to testify truthfully, competency to testify generally. You can use all these rules as reasons to object and get a witness kicked out or something they said objected to and thrown out. I know it looks like a lot, and first time through it's going to be a lot. But let's just focus in on the things you think might come up in your case. Okay? Negotiations, compromises. By the way, more than 90% of the cases never go to trial. Why? Because both the sides finally come together and work something out. You better be willing to settle sometimes rather than go to trial and take that risk, especially if you have a marginal case. If you've got a real strong case and good evidence, then you go for it. But if you have a strong enough case, it may or may not make it to trial because the prosecutor comes in and says, well, let me save face here, let's give you some probation, and then later on you can get that taken off your file or something like that. We've seen that. Sometimes that's what you need to do because you did kind of get yourself into it. If you're a completely innocent bystander, that might be different, but if it's something you kind of got yourself into, be willing to work it out. The Bible says, Matthew 18, verse 15, 16, and 17 is first go to your brother and work it out. Second part is bring a second witness, which is essentially arbitration or a private hearing. And then third is the court. 17 is go to court. Treat them as you would a publican or a tax collector. Those are actually the rules. They're just broken down in here. This just tells you how to get there step by step following some of the rules. And the procedures help with that too. These are just the rules of evidence. What is evidence? What's inadmissible? What can you object to? What can you get kicked out? And you can do this with motions. Just write a motion. Rule, motion to keep certain evidence out because of they're using religious beliefs or opinions. Whatever this says, and if you can find case law to support it, a motion is simply nothing more than citing the rule and then adding a little case law to it that supports that position and why that evidence should be taken out. And they're going to do it to you, by the way. So be ready. This is what, 90% of what attorneys do is they refer to this page and one of these two pages. One is civil rules of civil procedure, and one is the rules of criminal procedure. Now, again, if it's federal court, it's going to be federal rules. If it's in your state court, you'll go look up on Cornell Law is a good site to search for. You look up the California rules of criminal procedure or the California rules of civil procedure. Remember, criminal case is one where there is somebody going to jail for it. Where civil, it's not about jail; it's about a penalty or a fine or something like that. Okay. It's a suit of some kind. Well, sometimes the state can hit you for a civil case too. IRS can come after you civilly, but usually they come after you criminally because they just like to play dirty. But either way, you can end up in a civil or criminal proceeding. Know the difference when you start too. Like there's not going to be a grand jury or an indictment on a civil case. That's a criminal matter. All right. Don't know what these things are? Read this. I'm giving you free information to go look up here. Go to these two pages. Just go to Cornell Law, search for Federal Rules of Criminal Procedure. Just type that word, and then go here and look for the Federal Rules of Civil Procedure for civil cases. Again, this is for federal cases. And if it's your state, then put in California Rules of Civil Procedure or Oregon Rules of Civil Procedure. Just substitute that and you'll find the rules for those things. But I can tell you, if you know the federal rules, you'll easily be able to convert those into the state rules. But you can't cite the federal rule of criminal procedure in a state court. You have to use the state rules of criminal procedure, and if it's in your favor, you could get something thrown out or maybe get a case dismissed. If you don't know the rules, you won't know how to complain to the referee when they do it wrong, or complain if the other guy is breaking the rules. So you got to know some of these things, and it's not hard to find. You have free information. Google Scholar is a great resource. I mean, let me just type it in. There you go. And by the way, you might want to bookmark this once you find it. And now you can go, I want to look at articles or case law. I want to go to Washington courts or federal courts, see how it works for that. So if you're going to federal court, you can click on that, and now it's going to, say I want case law for federal courts or whatever. You start putting queries in, it's going to start giving you more choices. Okay? Like here's the state courts, state by state, and they have a court of appeals. Don't you think if appeals court rulings matter, that you might want to use appeals court so you can unclick the ones you don't want, or maybe it's your state Supreme Court or Court of Criminal Appeals for Alabama. Unclick everything else and just search that if you're in Alabama, for example. It's federal court, same here. Don't rely as much on Supreme Court rulings for federal as much as you do appeals courts, because appeals courts will use relevant Supreme Court rulings, and there will be more of them to choose from. For example, I want everything in the 7th, 8th Circuit, whichever one I'm in. I'm in 9th Circuit. I might unclick everything but that and only look for Court of Appeals. And I won't even want to see the local courts. I'll unclick all that. Just want Court of Appeals, 9th Circuit. That'll help me narrow down the cases that are for the circuit that I'm in that might help me disprove their elements or discount testimony or evidence that they're bringing in. If you use this together, just spend some time online playing with these things. And try to do it. If your case is started and you're working, even through if you're one of our Slam Dunk members, for example, you should still, after you do the basic things we teach you to do, come here and start reading about this stuff. Get used to it. If you have to get closer to trial, you may need to know some of this. Okay? I can't do it for you. I can't go inside your brain and get you, give you knowledge like that. You have to read and learn how to use some of these tools. I mean, what's it worth to you? Or, maybe Dances with the Stars is more important. I don't know. I wouldn't say football is more important. Would not say that. It's not. But when people ask me all the time, can I do this? Can I do that? And I'll annoy the heck out of you in the Telegram group when you ask me these things, because I'll say, well, what do the rules say? When you looked up the rule, which one did you find? What did it say? And you tell me what it says. Because if you can't tell me what it says, it doesn't do me any good to tell you, because I don't know it. I don't know. I go look it up. And then I look at the words and I think about it. And it leads me to, wow, Rule 5. Well, let's see, is there an appeals court case on Rule 5 where they violated something to do with the initial appearance? Now I go look for that if I think that's the defect in their case. And I start searching Google Scholar, appeals courts in the jurisdiction of the court that I'm talking about, whether it's state appeals courts or Supreme Courts, or if it's federal appeals courts. Now I'm going to narrow it down, zero in on, I think this is my theory. I think this is where their defect is. Okay? And you use these tools to come up with, what are the defects? Oh man, they didn't even have a grand jury. And what is a grand jury, and what are they supposed to do? Oh, well, here you go. It tells you. Can they do a grand jury indictment this way or that way? They ask me all the time on questions. I go, I don't know. What does it say here? Have you read it a couple times, and did they meet those standards? If they didn't, okay, here's how you challenge the grand jury. Motion to dismiss the indictment because something's missing. You see, you can copy and paste some of this right into your motion to dismiss. This is how lawyers just copy and paste all this stuff. They have clerks that can do this for them. And they just look at it and go, yeah, it looks pretty good. I'm not saying they don't sometimes write them, but generally this is so standardized, these steps. They do Westlaw research, then they look at the rules, and they go, hey, this guy violated Rule 6, or you know what, we screwed up. We violated Rule 6, and he got us on it. We better dismiss the case. You see how it works? They have to follow the rules. And it doesn't feel like they're following the rules sometimes. I get it. It feels like it's the world against you and they're all corrupt. But actually, maybe you just don't know the rules of the game and you just feel corrupt because you don't know. And you feel like, this isn't fair. Well, here you go. You have no excuse now. Go look it up. And then you just tell me it's not fair or they're not following the rules. And if it's not fair and they're not following the rules, then cite the rule, give me some case law, and put a motion together. What kind of motions can you write? There's a bunch of them. The How to Win in Court course gives you a lot of different ideas of when and how to use motions. It gets into more detail than we can get here. But my point is you got to know some rules. I don't know these rules off the top of my head. Every state has a different set of them. Every state has a different set of appeals court cases. There's multiple jurisdictions in the federal court that have different cases. I don't know it all. You don't need to know it all either. You just need to know, I got to know this set of things that I'm looking for. I'm showing you on screen, rules of evidence, procedure, case law. What are the elements? How do I keep evidence out using the rules of evidence? Rules of evidence. If they break these rules, you can say objection, Rule 103, or whatever it is. You hear this in court. If you watch trial programs, objection, relevance. Well, they're talking about one of these rules right here. Okay? And then you say, I can't memorize all that. I didn't say you had to memorize it. But if you've read it, you get familiar with it, you start taking notes, you're going to start going, wait a minute, they're getting irrelevant evidence in, and I'm letting it in. Are they cheating, or are you just uninformed? We perished for a lack of knowledge. Go look it up. Some of these guys are pretty smart guys, and sometimes they're not the smartest guys on the planet either. You'd be surprised what they don't know. But what they do know is that they can tell real quick when you don't know, and they're going to take advantage of it. Okay? I mean, wouldn't you if you want to win? So is it they're corrupt? Or is it they have some knowledge that you don't? Well, we're showing you that you can have the knowledge and you have the tools that they have. So go use it. Get knowledgeable about this. You will be empowered if you learn this. And I'm giving you all free information here. Free sources. You can do most of this. So that's the fundamental thing. By the way, we do have a few additional tools in your premium member area in case you go to the Start Here folder and a few other. We have a lot of examples. Like here's a defect sheet that's in your Start Here folder. These are certain things you might be able to look for. We've had people come to us and say they use this tool right here along with some case law and put together effective motions in one cases. Okay? So take a look at these. You can't just say the court lacks jurisdiction without knowing what you're saying. So this gets into more of a specifics of what is lacking. And then when you show that what's lacking or what procedure is defective and you can properly cite it in a motion, that's when the judge will pay attention to you and respect you. Or he'll say, oh, you're a fool, you need an attorney. They can tell really quick when you don't know what you're doing. You don't have to be an expert, you just have to know some basics. So, this sheet has some really good ideas on that. That's in the Start Here folder in the premium member area. So essentially that's my big picture view of the fundamental things you need to know and what you need to go focus on. Don't get focused on everything. They're going to have you focus on the stars in the sky, when what you need to do is narrow your focus to something specific, elements of evidence and supporting case law, those sort of things. And you'll be able to do this. You really can. Now, if you don't have a winning case, you don't have a winning case because maybe you're just guilty as heck and there's just, you've done everything wrong and of course you hire an attorney and he doesn't do anything but just negotiate a deal. That doesn't make you innocent. You did whatever it is. So you have to start with what did I do to kind of get myself in? What would I accept as minimal damage for a settlement? Be willing to go there because I also have a big saying, pigs get fed, hogs get slaughtered. So be careful. You may have learned somewhere on the internet, hey, if I just file a secured party creditor document and a UCC1, I can get away with everything. No, that's not real. Come on, get real. Because there's still common law. There's laws of nature. And you can't do harm. And somebody has been harmed or you have endangered somebody, then you did it. Or maybe you did no harm. You were just speeding, but you're going 80 miles an hour and you went right past me walking down the street with my baby and I'm in a stroller. Hey, I don't want people like that doing those sort of things. That endangers me. That's still a danger. So maybe you didn't do any harm technically, physically, but you're a danger to a lot of people. So be careful. I've turned down people that come to me and said, I ran down the street, I ran through a wall with my car, I was bashing everything, but I didn't hurt anybody. I'm saying, go to hell. You're dangerous. You still got to use common sense. We have a social contract. Whether you want to call it a contract or not, you do. You have a contract to be a good thing in your society. Don't endanger people and harm people. Even if you haven't physically harmed them, you may be a danger harm. Okay, there's an element there. It's a gray area, I admit. It doesn't allow you to go around being a fool. So take personal responsibility as well and work out the best thing you can and try not to go to court. Your motions, your actions, the procedures, you start showing them a few procedures in case law, you'll get a lot further than just going there being a fool. And I read to you a couple of weeks ago some scripts that you can go into court with. No, I don't say stand behind the bar. We used to kind of say that. I'm like, no, that doesn't work. They have a way of getting to you now. But there's a way to go in and set up everything and have an actual good legal argument as to why they can't do much. Okay, entering a plea and things like that. Not until you know the nature and cause. Very, very important things. But most people just say, sure, I understand. No. Your attorney will say, just say yes, just say yes, just say yes. The problem is you're contracting now. So now what you're under contracts, they can do all kinds. You can contract that they can come to your house every morning and slap you in the face. And that's kind of what you do with a driver's license, for example. There's a whole lot of underlying contracts. You have the right to read them, but if you sign it, you say, I accept it. That's too bad. It was disclosed. It's available on their website. It's available when you sign up. Yes, you do have to have a breathalyzer test when they ask you to, because that's the contract. Well, they don't have a right to touch my body. You can contract away all kinds of things. So don't get cocky about this stuff. Be intelligent about it, and you'll get much, much further. Okay, So that's it in terms of the general subject for tonight. I'm going to go ahead and open this up for some. Well, first I want to know success stories. As always, if you have your hand raised, it better be for a success story. If you have it raised, lower it. If it's not a success story, we always start off there and try to get those in first. Somebody that can add, like, you've done something, here's what's working, not so much just a general question. And I don't want to necessarily hear a long story about your case that I cannot keep up with. I can't even concentrate for more than 1 minute. So just give me a basic question, because we cannot resolve entire cases here. Hopefully you can keep the questions relevant to what we're doing here tonight. Okay? So it looks like, hey, I recognize that face. It just came on. Is that Daniel?
Buenas noches.
Buenas noches.
How's it
and
going?
mucho nachos to you on top of that. So.
Buenos. Oh, I just had some tacos too.
There you go.
So that was really good. I just want to just go through a success that I had recently. My case is not over yet, but I'm suing the School Board District of Broward County and the Fort Lauderdale Police Department for trespassing me off. This case is still going on. The last time I spoke to you, it was still going on. I'm doing everything myself. Spending a lot of time in the law library with corpus juris secundum. Corpus juris secundum, I think I want to be in that casket with Mr. Corpus. Because I mean I've been spending so much time in the law library. It's just, they got to kick me out of there. So anyway, what I went is we went into mediation, just to be real quick, and I was like, damn, what am I going to do? Mm-hmm. I don't know how to negotiate this, because there's a way to negotiate on how much your case is worth. So I was trying to figure out how that worked. So when I went into mediation, I was like, damn, what am I going to throw out there? Should I overdo it? Should I underdo it? Just use your brain. Obviously, I didn't use my brain, and they asked me, well, throw us a number. I said $3 million. They laughed at that. They literally laughed at that. So my success to this is this. I said, you know what? Let me call the underwriter to the insurance company. Boom.
There you go.
She explained the entire breakdown to me. She said, and she even added that if the insurance company agent bargains that negotiation wrong, that'll be her last negotiation. You got to understand that it's a lump sum of money, and you're getting paid 10% of whatever it's worth. And she broke down the whole thing. I got it in writing. I just didn't want to go over it real quick. So if you're having I'm getting really good with 14 USC, 42 USC, 1983 civil rights violations, deprivation of color. There's a whole bunch of them that fall under it. This is crazy how much you could apply to them, but this is a civil matter, so just be careful with that. I'm now doing videos on YouTube because I'm spending so much time with the case law, and I'm looking at details, especially equity, but I'll talk about that in the next question. But that's what you want to do. You want to go in there and you want to contact the insurance underwriter, ask them to explain to you the breakdown of what your case is worth, and they'll talk to you.
Nice. That's a good idea.
They'll talk to you, but
the good news is you got to talk in numbers. That's way down the road. If you're talking numbers, they're making offers.
Oh yeah, I mean it's one of the most important things for you to wrap your head around, because knowing how much your case is worth is going to play a real key role. You got to know how to come at, because it's going to be a back and forth thing. So if you can weigh the numbers out correctly off the first, because they're going to come to you first and ask you, and then it's going to go based on that. You want to get as much as possible out of this. You know what I mean? You want to negotiate it right. So get with the underwriter to the insurance company. In my situation, it's Chubb. Chubb, and there's so many companies out there, man. It's just crazy. Oh, and what I want to tell you, where I learned the actual public entity liability policies was here. He gave me a lot of valuable information, and then I started going into, and you guys got a great, I mean, you guys got a great Bonds for the Win. When you just go in there, it tells you a little bit on how to do it as well. Not a little bit, a lot.
Mm-hmm.
You know, so.
Yeah. But, you know, like a case like his, for example, he's in there also on a bond, so we're gonna talk about that. Maybe you and I can talk about that. But that's what holds everybody in prison is a bond. And
Absolutely, yeah.
You got to get it replaced. But anyway, I like the fact that you're focusing on your civil case. You're taking it to a level where they're actually talking numbers. That's really huge, you know, because they're considering it when you're talking numbers.
Let me just tell you that here is where I got the first. Here is where I got a good taste of how and what I really wanted to do with my life. When the first time I heard you speak, you were very articulate, you were explaining a lot of things, and I started watching YouTube videos, and I started applying myself. I started saying, man, this guy, what he's saying is true, and I look it up and go behind what you were saying, and there it is. What was it? If I can remember off the top of my head, it was IRM Manual 21.7.13.3.2.2. I even memorized it. It was, once the infant receives a social security number, it now has established a guardian-ward relationship. And they have see, what people don't get is this. You pull the tags off your car, you do this, you do that, you do this craziness. Don't learn it first. Why are people going to the extent, and then they come to you, and then you have to kind of like be annoying because they're being annoying, asking you the same questions over and over again. So you have to take that and just reverse psychology without being rude and saying, you know, where was the law? Or did you read it? What did it say? You know, so thank you, TJ. Thank you all you guys over here, Lawrence. Everybody appreciate you, Lawrence. I know you're back there. I can hear you breathing.
He's a heavy breather somewhere, I'm pretty sure. But cool. Well, thank you very much. Appreciate your good luck. You're on the right track. Now you got a number. You know, in my negotiating tactic, the only thing I give everybody all the time is I never accept the first offer, and I never make the first offer. They say, what number do you want? I said, well, I want $3 million. And then they say, ha, ha, ha. I said, well, what's the best you can do? That's my first negotiation, is what's the best you can do. And no matter what they say, guys, write this down. This works in business and life and everything. No matter what they say, they come back and you say, well, is that really the best you can do? And notice I'm not saying, how about 100? How about 50? And I never engage in numbers. I always ask questions. And I can tell you those two questions, you know, what's the best you got, and is that really the best you can do? So there's just like have a follow-up offer, counter-offer to their offer, but you're asking them to put the numbers on the table. You'll have a number in mind that'll work. And then you say, so if you can do that number, when can we close? I don't say yes. I just say, if you can do that number, when can we close? This is called conditional acceptance. You're always like listening, asking. Listen, ask, listen, ask. And usually by the time you get to the third question, you've nailed it down to something. And this works for all kinds of things. I had a guy painting my house today. He says, oh, this is going to cost this much more. And I said, really? I said, you didn't bring that up in the first offer. What's the best you can do? Well, I think that's about all I can do. I said, really? That's all you can do? See, I'm pulling it away. I'm walking away now. Oh, okay, well, we'll do it for this. See what I'm saying? There's always a counter to whatever they say. And I'm doing it in the form of a question or an inquiry. Is that the best you can do? Is that really the best you can do? You learn to say those words, you'll buy everything, you everything you want in life cheaper. By just always asking that, even if it feels awkward.
Yeah, always. Yeah, and I just want to let you know that I promote this. Was one of the websites I promote. I also promote people with traffic. I notice there's a lot of people trying to learn traffic. Eddie Craig has a free class every first Thursday of the month. Everybody should take it. It's free. He's an expert in traffic. I really, really like his techniques because
He's an ex-cop, isn't he?
no, he's an ex-sheriff. He wasn't a patrolman.
Oh, yeah, it's a cop. I mean, yeah.
Yeah, he was a patrolman, but he was part of he was a sheriff. He was legitimately a sheriff, and he does an excellent, because you see, even though you're accepting benefits and privileges and they have jurisdiction, in their jurisdiction, they have to be fair. And when you look at, oh my God, TJ, when you look at some of the statutes, it's 100% ridiculously written and fraud. And when you bring it to their attention that this is absolutely ridiculous, they're like, man, they got us cold. You know?
Yeah, no, I've read statutes to people on here just to give you examples and say, read it really carefully. It doesn't even say anything. It's a bunch of circular language that's hard to understand. So how can I be responsible for something that doesn't make sense to me?
It makes no sense, a lot of the statutes. And every time, he did the statistical numbers.
You're slow, not fast. That's the key.
He did the statistical numbers. Every time someone is pulled over, they make at least one mistake. At least one. And then from there, it goes up to at least 20. It's just nuts. It's just crazy. Traffic is a separate thing altogether.
Yeah, but it's the same principle in the sense that like when I talk about elements, like they'll talk about elements required for a tax violation or something like that. If you read the statute slowly and the elements required, you can usually find case laws or something where they'll list the elements and how it was proven or disproven. It comes down sometimes to a word that doesn't make sense in the whole sentence, or the grammar is so bad in some of these things they write that it doesn't. How could you be held responsible for something you cannot possibly comprehend? If you read it fast, you'll think you understand it. Oh, it says this. Well, wait a minute. It also says "and" in there, or in there, or it uses a word that has multiple meanings. You can zero in on that one thing and show that disproves that they have an element, or something like that. In other words, you're trying to prove the elements, and the statute itself might be your proof.
It's just ridiculous.
How you just break down the words and start saying, wait a minute, I really don't know these words. So
is it just me and you on here? I'm looking into. Oh, there's more people.
Oh, there's more people.
Oh, okay. Well,
I'm going to get to the next question, but I want to just point that part out.
Oh, no. 100%. Get to somebody else. I'll put up the queue because I want to talk about something else later.
Okay, catch you there.
Go.
All right, Scott is up in the queue. Scott?
Oh.
I hear a bunch of typing. What is that?
I guess I don't have it muted. Can you hear me?
Yeah.
Okay. Why did you say that the state national thing, the status correction, is not a thing?
I don't think it's helpful. I haven't seen evidence that it makes any difference. Now, if you get evidence that it shows it dramatically changes something, show it to me.
Well, this is just from what I've seen, and maybe I'm wrong, but a lot of times what happens is that this embarrasses the court. These things come out, and the court just makes these cases disappear.
How many times have you seen that?
Well, you can't see it because the cases are gone.
I get it, but how many times can you show me a case where somebody did that first and then it just disappeared?
Well, I can't.
So they dismissed it.
Well, I can't, and it's because...
That's the problem. I've yet to see the evidence that's how you win a case.
Well, right, and I see that. I comprehend why you're saying it.
I'm not saying it's completely wrong. I'm just saying why spend time on something that's really not... I mean, just because I walk into court, I go rob a bank, and then I walk in halfway through the case and say, I filed my state national. Oh, gee, we need to dismiss this case. And, you still got the money and everything. You really think that's going to actually help?
Well, no, I don't actually think that's even going to happen, because at a certain point they're going to be able to thwart that because you did cause harm and you did injure someone.
Right.
But what I'm talking about is having to do with basically making things that are not harmful crimes go away, and those cases disappear as well.
Well, sometimes, though, they dismiss those cases because they're bad cases.
And I don't doubt that. I don't. And I'm just curious as to, because...
But I found, here's a big mistake. Let me tell you, help you here. Here's a big mistake. If you have a winnable case, and then you jump over to, well, I filed a UCC1 and I'm a state national now, we're going to go, this guy's an idiot. He's got a winnable case.
That's not what they teach, though. They don't teach you to do UCC1. They teach you to...
Well, whatever. I'm just saying, there's a lot of stuff out there. State national, UCC1, all that. I have just yet to see that. I mean, why would you jump to something like that when you have a winnable case? They have the defects.
Well, I don't look at it as jumping to anything. What I look at it is as a remedy, because there's fraud, and there's a problem with the word citizen. The problem with the word citizen and the spelling of the citizen. And also,
I agree with that.
So okay, what it does, this is just my experience, and I'm pretty young at it, and I've only been a state national for about 1.5 years or 2 years. And in this process, what I've noticed is it's a basis.
By the way, you're still a U.S. citizen, even though you think you're a state national. I can prove it.
But I can argue that I'm not.
But you
are. And some of the things actually... because
the 14th Amendment doesn't say you're either or. It says you can be both.
I'm sorry?
The 14th Amendment, it's all about the 14th Amendment. That merely says you can be both. You're not either or. In other words, you can be both at the same time. In fact, we all are. I'm an Oregonian and I'm a U.S. citizen at the same time.
Well, the problem with being a U.S. citizen is a citizen of a corporation after 1871.
Sure. So a state citizen is a state up.
But that's fraud. I can't be a citizen of that. I can't live in a state.
No, you aren't, but you're using the citizenship state. It exists.
No,
the citizen exists whether you acknowledge it or not.
No, I am actually not using the word citizen. I've actually repudiated the term altogether. The term, you could, by your own self-determination, you have the right to self-determination.
Sure, yes, I agree.
And so by your own self-determination, and once you do an affidavit process, the way that David Straight lined it up, once you've done that affidavit process, you've repudiated these terms and say, I don't identify that way. And if somebody can walk in and say that they're a woman, and so with your right to self-determination, if you've repudiated those monikers, then it's pretty simple. I'm not that. I can prove it. I have an affidavit that proves it's gone unrebutted, it's matured, and it's a matter of public record. And so if someone takes you to court...
I agree. I think if you do that in advance of a situation, that might be helpful. Might be.
Well, that's what it's a basis. That's the
a lot of people base on this. Yeah, but I still robbed the bank. Okay, well that has nothing to do with it. Because your actions speak louder than words.
I understand that. I comprehend it. But there's this problem, this one major problem, and that these companies, these for-profit corporations, and I can prove that, these are for-profit corporations.
They are. No question about it. They're all registered EINs. They all have QSIP numbers. They all probably deal with Mellon Bank as their back-end accounting. I understand all that. I'm just simply saying when you're dealing with a specific charge, and you went on the merits of that first.
Well, no, I don't approach it from that perspective, and I'm not saying you're wrong. You're way out ahead of me on a bunch of levels.
Yeah, no, I'm just saying I'm open to what you're saying. I'm not saying it's not right. I just haven't seen people have success with it.
And I see that. I can comprehend where you're coming from with that. And we both agree that it's all words when it comes into court, right? I mean, there's
I can disqualify a case on the statute alone.
Right. But the whole point of it, I guess the point that I try and look at it from is it gives you the basis to be able to work the case all together if you can, if you have a competent judge or if you have an attorney that goes, hey, this guy's right, But they don't often follow their own rules. And that's what I've personally been experiencing individually. I've seen that, no matter what I do, what I say, they have categorized me as an enemy. And so that's a problem.
That's the automatic presumption.
Right, but that's a problem, and the problem can be remedied by utilization of being able to pierce their veil. And that's how...
Oh, I agree. You can approach it from that standpoint. I mean, no doubt. You've got to be awfully good at it. And most people, that's a lot harder to do than the stuff I teach.
Well, and I'm not saying I haven't really experienced that, but I've heard enough about it to see the general overview, to say, okay, what's the big picture on this? Because if you can see it from the macro view, and then you move into the weeds, it makes more sense of what you can and can't do and pull off,
No, I mean,
reliably.
they're going to test you. I always say they're going to test you to
Okay.
see.
Oh, yeah, absolutely.
They're going to put you in jail, give you bologna sandwiches, give you an ugly roommate, and who says, I love you every night. And you've got to keep them away from you. They're going to put you in that situation. But my point is you don't even have to do that. If you do some of these things wisely, you don't have to try to dance that. And it is important. In some of my own documents, we come in there declaring that we're not the estate name, that's what it is. It's not about citizenship. It's about contract to me.
Well, it's also, too, about unlawful joinder and admitting that you're a corporate entity. That's what I see as the main problem.
Oh, no, absolutely. And you can go into court and clearly state that I am only the beneficiary of the entity that's charged.
Well, you can
and
also
I'm not
say
the
that you're the
liable party as a trustee. I totally get what you're saying, but that usually only goes so far. If you got a winnable case, go for that.
Well, you can also say that you're the executor of the vessel, because that's the truth, too. This is a corporation that was created in your name, but it isn't your name, and it was.
And you prove you're the executor of your vessel.
You actually are the executor of the vessel and the beneficiary of the trust, but they also consider you the beneficiary and the trustee.
Okay. And so you've got to be careful how you state these things, though, because what I learned is you go in there saying I am this and I am that. Everything you say I am, you have to prove. It's hard to prove.
Right.
Well,
that's why.
I would say I see no evidence to the contrary that I am that.
Well,
so
that's why you state. That's why you
put the burden of proof on them.
Right, but that's also why you say that you're a man.
Like, no, I don't even say that. I'm saying prove that I am the estate. Prove that I am that name. Put the burden of proof on them. Every time you say I am, you have to prove it, and you have to argue it. And once you argue it, you're the defendant. That's how they trick you.
Well, that's true too. That's true. And so what happens, though, I think that this is what I've experienced just in the last few months of going with the judges. There are judges who see the truth of the fraud, and they know that they're operating that way. And there are judges who don't care. And there are people within the system that just think, hey, it's government, and they're on top. And everybody has to do what we say. And so what I experienced, actually, I was recently arrested. And when I was arrested, this cop, they knew about me. They already knew who I was, and they already knew about my status correction and all those different things.
Mm-hmm.
And one of them said, are you a person? And I said, no. And he said, well, if you're not a person, we can do anything we want to you. And it's the opposite. If you are a person...
Your answer gave them permission.
Just the answer?
You said no. That's an argument.
Well, he asked
me if you're not a person. I said, am I required to be?
Well, and then
what
he
is
asked,
that?
then,
how is that defined? What definition are you using?
Right, and I see that too.
Questions
that's also a trick. That's also a trick. And when they say, "Are you a person?" and I said, "No," he said, "What
are you a man?"
No, he said, "What are you?" And I said, "I'm a man." And then
I arrest men all the time.
Well, no, they don't think that way, because they think these cops are, no offense to cops, they're rocking 100 IQ. They're not really.
Yeah, but some of them is simply trained. Hey, when you hear this, you just do that. When they say they're a man or you're a person, you ask them a few questions. They got good at giving you trick questions.
Oh, absolutely. And
your answer gives them permission.
Right, and
an argument gives them permission.
I am not arguing with you that you're wrong, but
I'm just trying to make points as you make them.
Oh, and the points make sense, but because if the goal is to stay out of their admiralty courts, that's really the goal, is to stay away from them. And if you can point it out, like, hey, I don't fit into this box, and it's a decent argument and prior to any case, well, then they don't really have too much choice. And then if you can back it up and say, hey, here's an affidavit that it's going to point out all these different things that you're actually doing, unlawful joint or unlawful conversion, all these different things.
If you can see those things and you can prove them, you can put it in an affidavit, yes.
If they're
you can't put an affidavit. People put affidavits together to say things that they can't prove. Then it's not an affidavit anymore.
Right. They have to be able to prove it for they have to be able to disprove it too.
You say, I'm not a 14th Amendment citizen. Oh, really? Well, were you around when they wrote the 14th Amendment? Stuff like that is what they do. You say, I see no evidence that I am. Present me evidence that I am. So you turn it in, the burden of proof on them with those statements, or ask questions. That's the trick to doing what you're doing. I hear people do it all the time. They make claims. As soon as you make the claim, you got to prove it. And that's really hard to do.
See what happens too, though. This is what I've noticed is that, like I said, there are judges that know the truth about how they function, and they function under fraud. It's been proven over and over again. And so once they see that, there's good guys who say, yeah, we function under fraud. And
I disagree that it's fraud. I say they function under contract law, which is in the Constitution. Well, and you don't know what game you're playing.
But the thing is, as soon as you learn it, and as soon as you know what the game is, and you can outword them.
Because once you say fraud, you got to prove it.
Well, the fraud's very simple. You prove it through affidavit process. If you can.
How does your affidavit prove a fraud?
They acquiesce.
Do they?
Well, if they don't respond,
that's an acquiescence. They don't respond. But my point is if your affidavit says anything that you can't prove, then it's not an affidavit anymore.
Well, if they don't respond...
A lot of people write affidavits all the time. Listen, I see affidavits all the time. I'm just trying to point this out. I'm trying to teach you how to write. If you want to do an affidavit, state only things you can prove. And I mean prove. Or you can say, I'm not a U.S. citizen, and I see no evidence to the contrary. Please provide the evidence. Now, you put the burden of proof on, and that's just another way to state it. But you always want to throw the burden of proof in the form of a question or a statement that puts the burden of proof on them rather than you stating it. Because you know what? I can say, I've seen no evidence to the contrary, and you have to know what admissible evidence is, what I was talking about during the lecture. Admissible evidence is something you can state and you can verify. An affidavit has to be, everything in there has to be admissible evidence.
Well,
or it's not, no good.
This is what I've experienced with the affidavit process. Once the affidavit is matured, that's considered an acquiescence, and then they have to disprove what you pointed out.
Right. That's how you have to stand on it for sure. You're right.
But they just don't. They just never try. And so when it comes to recently, I sent 2 affidavits off. One to the district attorney of Sacramento, and one to the judge who was involved in one of my cases. And when I did that, they acquiesced. So now it's an instrument. Now all I have to do is record it properly, and I can use it in a suit. And they're not even going to show up to the suit. I don't even have to go into court. I basically go into the courtroom and file the suit. When it goes and it matures too, by this time they're not even involved. Right. Now I don't know the whole story about the suit, but I see the big picture about how mechanics work. And then you take.
Well, by the way, let me give you a little clue. Our friend Daniel was on here earlier. Would tell you this: don't go for a suit. Go for their office and bonds, and then the bonds is an insurance policy. You go make insurance claims.
Right. And that's what basically.
You see, this isn't about you. This is about them now operating without the proper bond, violating their procedures. So don't forget, you still have to know how to go after their procedural defects.
No, I see that. That's what I really do.
You want to win.
Huh? Right, and there's not just one way to win. Okay.
No, but I'm saying there's rules that you follow that can set up your chances of winning to be much, much better.
Right, and so like I said, but the goal is in the state national community. This is what I've seen, is to be able to tell them using their own processes and their own rules what they've done, and then hold them accountable with the utilization of their bonds. And if they don't have a bond, or if they don't have an insurance policy, you go after them individually because you can't. Because the reason you can is because you're a non-corporate entity by law. And so when you're the non-corporate entity and they're the non-corporate entity, but they're operating their vessel and you're operating your vessel, then all you have to do is prove that they've misoperated their vessel and they violated the law. And then you can take care of their bond if you want to do that, or you can go after them individually and win that way. Yeah, so it's a multiplicity of different ways to go about this. And so it's not to say that what you're doing is in any way a poor choice, because it's very, very strong.
If you have a winnable case, I would say. Right, if you don't have a winnable case, you might try something else, but certainly you'll lose.
Right.
A lot of people don't.
And this is like the way I approach it is when from the state national community, you don't necessarily even happen to have a winnable case.
I understand, but I'm saying if you have a winnable case, why would you do anything else? Because guess what? This system will honor you if you follow the procedures.
Absolutely, except for when they don't.
It's contract.
They're doing it now, where there's rules and there's things that they have to follow, and they're not doing it. This is their own rules. And so why?
Oh no, it's because you're not compelling them to. They don't have to do anything. That's the way the rules work. You have to compel them with admissible evidence according to the rules and prove the elements. Those are the rules they have to follow.
And I'm not saying you're wrong, but they don't. Okay, they just don't. And so if they don't follow this, and you've compelled them in such a way by the utilization of
right, which is why there's an appeals process, because in appeals cases is when you find defects in their procedural rules that win.
Okay, and that is a great.
But you can't go to appeals without those properly without evidence of them breaking those rules. That's your best chance.
It's the best chance within the system. Okay. But what the state.
Well, 99% of the people are still within the system. That's who we're talking to here.
Absolutely, and I don't disagree. But what I'm saying is once you get to see that other direction, then what it does is it adds another arrow to your quiver. And so, if you want to go ahead and fight the case, go ahead and fight the case. But why would you do it if you don't have to?
But we have a whole class on using equity and going that route. This isn't that class. And that's a very narrow class of people. They're doing a very narrow process, and status makes no difference whatsoever.
Right. In equity, that's absolutely true. Status doesn't matter. I totally get
You already have it.
But,
you have all you need.
But what it is, too...
You can sign a piece of paper, and you can write a contract, and that's all you need.
Right. And you can operate that way. But then what you do, the problem that I see, and the problem that I think that all of the people that are in the state national community can see, is that there is an element of fraud which is in your face. Is once you see this fraud, you can't unsee it. And so for me, I had to ask myself a serious question. I had to say, okay, do I want to function under fraud? And the answer was just resounding, no, absolutely
right.
I don't. And so that's where the admiralty law and the citizen and all these different things.
But see, admiralty law is not fraud. Contract law is not fraud.
It's not that it's not fraud or that it is fraud. The fraud part is the corporate entity that they make you admit that you are through their deceitful language.
Yes.
And so once you can master that and go, hey, this is not me. You're talking about a corporation, and
Absolutely.
It's your rules that say that it's unlawful for a corporation.
But the reason you have to understand where they're coming from, and they're coming from, hey, the Constitution says we can do this. It does.
Well,
called contract.
Constitution.
Yeah, I know, but that's who you're talking to. So you always have.
I know.
I want to talk Chinese with somebody. You better talk Chinese, and
Right, but what at the end result is.
You want a ruling. You have to have jurisdiction for them to give a ruling. If you want them to dismiss a case, they have to dismiss it based upon one of their rules. So if you don't, even if you do all this stuff, you got to sometimes give them what I call give them the out in their rules.
And that's what we do too. We do give them the out. We say, you have an option. I just recently gave a judge an option where I said, hey, I've got all this stack of admiralty stuff that I can put the screws to you with, and then I've got this empty case that you've conflated onto one court date without me asking you to. And then I said, here, you got a choice, basically in a nutshell. We can settle this in admiralty where I've got you dead to rights, where you admitted by acquiescence that you are under fraud. We can go that route, or we can go into equity. And I got
if you get those words out in open court.
Right, but I got into equity in a private admission, where I had submitted these documents through the court, through the deputy CEO.
Did they admit it to it, or did they dismiss it because of that?
Well, there was a problem. Okay, I wasn't versed enough in equity, and when I wasn't versed enough in equity, I was listening to people who were telling me what to do to get into equity. And I didn't know I was already in equity. That was the thing. I walked in, the courtroom was empty, except for a court reporter, or a clerk, I'm not sure, and a bailiff. And I walked in, and I told the judge, I'm here by special divine appearance, asking for a constitutional court record and a summary judgment of truth and facts in my affidavits. Mm-hmm. And when I walked up, I'd already done this twice before. Okay, and when I walked up, I basically said, motion for leave of jurisdiction, Your Honor, and he said, we can't go into equity with the district attorney not here. And
He's probably right.
He pointed to the district attorney's seat with his gavel. And I was like, I kind of waited for a second. I said, Your Honor, we should move into equity. This should clearly be heard in equity. And he said, we can't go into equity with the
That's right. He's right. He's right.
What happened? Because the district
was
already in equity.
Private and a public.
We were already in equity. It was there.
I get it, but he can't acknowledge that in public.
Right. And so I was trying to get exclusive equity, and I didn't know the way to do it. Okay.
Yeah.
And just recently, I knew the way to do it, and it was a new judge, and I put all the proper papers together, and I asked nothing but questions because I saw there was a district attorney there, and I was like, well, if the district attorney's here and I'm asking questions, there's a good chance for me to get into equity. And the judge just ignored everything and told me that he didn't understand my language. Well, he'd already seen the papers I'd given him.
Doesn't matter. He'll say he can't see he won't see what you're doing. He uses the words see or hear a lot. And those words are significant, contractually speaking.
He said understand. That was
okay. Understand.
That was the clarity. So he didn't hold it up.
There's no contract.
He didn't hold it up. But there was no contract, and so they pushed me on to trial. Okay? And so here I am, I'm stuck in the wind, going after them, and I don't know how to operate a trial. I don't know how to get and that's what happened. I was in equity. I got booted out of equity, and they sent it to trial. And when I went back into trial, trying to get back into equity,
they made you an offer, and you accepted it.
Okay, wait a minute. Which offer did they make me?
Go to trial.
I kept telling them, it's like, why are we going to trial? I was like, this makes no sense. Because it didn't make sense. That was him getting me into contracts saying we can't go into equity with the guy here. So I was booted right back into admiralty.
Yeah, that's called an offer.
So, and I had no idea at all. I was, and I'm facing.
Well, I got to try to get questions here, and so rather than discussions. But
and that's going
really good discussion. You have a conclusion, really quick, or?
Well, the conclusion is, as far as it goes, I
think
that it would be unwise to discount the state national community and what we're doing right now, because I think that it's really working.
If I could see some examples of somebody, what they did and what they worked and what they said, we can consider that. And I know what a state national is, but it's also a U.S. national and a U.S. citizen.
It's impossible. It can't be.
They can both exist at the same time. Yes, they can.
Well, I've repudiated one altogether by my right of self-determination. So it can't.
I get it. But have you ever had a passport? Did you ever have a birth certificate? Did you ever have a license? Did you ever show up at court and accept a benefit? Did you ever get on a public road and use those public roads? I'm saying there's all kinds of little nexuses that they can create. That's my point. Whether you say you are or not, I'm not one either, but I am one at the same time.
Okay, well,
you have both.
Here's a question.
It's like that judge said, I can't hear equity here, but he really was hearing equity. He can be both at the same time, but he can't do it in the same venue. The court has a public and private side as well.
Okay, well, when it comes to
just like I have a public and private side.
Right.
I have a vehicle that I use when I need to, like a corporation, call it a U.S. citizen, whatever it is. I use it when I need to.
But you don't own that.
Because if we gave me a system with no money, I got to eat. But on the other hand, it doesn't mean that I am that entity. I have an LLC, a company, but I'm not the company.
No, and you're completely allowed to own and operate those things, including your own vessel name. You're allowed to operate in public and operate in private. But
it's the capacity of the hat I'm wearing at the time that changes.
Right, but the problem is that when the terms are conflated, and that's where people.
Oh, I know it can be confusing for a lot of people. That's why I use the example of a company. If I own a company, if I'm a stockholder, it doesn't make me the company.
Right.
It has the same name as me, but it's not me. But I can use it when I need to interact with commerce. That's why the only true way, and I'm going to say this unequivocally, the only true way to truly operate in the private is to have a private, properly constructed common law trust that you don't control. Then you can operate in the private. And you can actually operate in commerce, but you're not operating as the trust is. That's
part of the teaching in the estate national community.
Yeah.
That's part of it.
Because if you set it up wrong, you just broke the whole thing.
Oh, absolutely.
If you operate it wrong, you destroy it.
Absolutely. I totally
Because people
agree.
do it wrong all the time. They say, but I got this kind of trust. I don't care what you call it. How is it structured? Who created it? Who is the grantor? Who are the beneficiaries? How do you move money in and out? How do you interact with commerce? Do you have more than one entity? I ask all these questions, and I can tell you that's how quickly an attorney or a court can break it down, too.
And
It's so easy to do it wrong.
I know, I get it.
And that's truly operating in the private, because you're never operating in the public.
Well, with trusts are really confusing as it is.
And yeah, so, exactly. No, most of them are totally bogus. I got to get to the next caller here, though. Can't go into that lesson plan.
Hopefully we'll talk in the future about this.
Okay?
Thank you.
Okay. Gregory, I see just an email address says Gregory Lynn. I'm going to limit it to questions at this point, by the way. Gregory Lynn. Hello? I don't hear you. Maybe you're muted. Check your mute button on your mic or on your console for the conference. Or I'll go to the next one. I think I see Daniel snuck back up in here. Gregory Lynn, figure out what your audio issue is and raise your hand again.
Hello?
Hello?
Yeah, hi.
Hello?
Can you hear me?
Yeah, you're kind of boxy way out there, but go ahead.
I didn't. Sorry, I didn't have a question. I think I hit the button to raise my hand by accident.
Okay, no problem. Like Daniel, you're back up. Come on, guys, got some questions. This is our quick Q&A time if you want them.
Oh, no, I just wanted to add to a little bit of what the young man, the state national, was referring to. Sounds like a very smart young man. I think he's going in the right direction. I just think he needs to keep his mind a little bit more open. Ashwander rule number 5. There's 7 Ashwander rules. You cannot challenge the constitutionality of something if you're accepting a benefit and a privilege. Now, I run into state nationals all the time who don't understand this.
Yeah, well, let me tie this one point in with
Go ahead.
You can't say it's not constitutional if it's in the Constitution. Article 1, Section 10 says, essentially, Congress shall make no laws abrogating contracts. In other words, contracts are superior and acceptable. And as a matter of fact, they created Article 1 courts, which are contractual-based courts, admiralty courts. It's in the Constitution. They can push you into commercial law.
Right.
So there, get over it.
Yeah.
Whether you're a state national or not, they can still pull you in there and adjudicate it there.
That's right. 27 CFR 72.11. Read it. Commercial crimes. Now, I sat in a tax case where a guy hadn't used the Social Security number in 20 years. They charged him for, he was illegal in the country. He didn't even have a Social Security number. He was a good friend of mine that I practiced Brazilian Jiu-Jitsu with. I sat in his class, and listen, check this out. They sat in there. This guy wasn't even born in America. There wasn't even no birth certificate present.
So when they think matter. Okay.
When they got him into court, they asked him, they said, are you using the Social Security number? No. Are your children in public school? Yes. They asked him, look what they asked him.
Crossed the border last month from Texas, and did you accept the cell phone we gave you?
Right.
They gave you a cell phone.
Did he ask him, are you using a driver's license? He said, yes. He said, let me ask you a question, the prosecutor said. He said, how did you pay the stenographer? He said, I paid him two $100 bills. They got you. You're using Federal Reserve notes, your children are in public school, and you have a driver's license. You see? This isn't illegal without a so you are the citizen. So I just wanted to explain to you. And I was going to get to this.
They do it.
Article 1, Section 10, Clause 1 of the Constitution is the contract clause. It's above the Constitution. The only thing above that is equity. You're going to have to learn equity.
But they're following the Constitution, and you're following it too by using the benefit.
Right. And
factually speaking.
You can't argue fraud. You signed the contract. How you going to
again, you don't have to sign it. Just your mere acceptance. And when they arrest you, they say anything you say and do can be used against you. That's a contract.
Tax protesters go down all the time because they do not understand the basics. And let me give you two basics.
Yes,
I put my number here so I could show this to you under law. The basics. You got to know the difference between public and private. When you went into court, you tried to mix processes. That's why they didn't accept the equity. If I'm not mistaken, you mix processes. You can't mix process with equity.
When we teach our equity process, we are very strict about every single word you say. If you make one single claim, it's over. Because now you got to prove something. You became the defendant. You switched roles. And it's over. That quick.
Listen, there's two places where you could find equity case law. And I'll show that to people if you call me. And corpus juris secundum, put me in the casket, man. But the young man who's the state national, you're very articulate. I'm not trying to take anything away from you. I just think you're a really smart man, and you're going to go places. But you need to keep an open mind. And you got to learn equity. You have to, because it's a great thing to fall back on. I recommend. I've already got 3 people signed up. I'm trying to get more, but I've already got 3 people since they did the equity course in different states. Friends of mine signed up for the equity class, and they took it, and they, did it, whatever. But I'm learning it through corpus juris secundum, the exemption and set off. And then you go into the UCC version of rescission of contracts. Now you're working with something there. But hey, listen, I just wanted to say that I definitely promote the equity class. I promote the website. TJ, you've been fantastic. The young man who's the state national, you're very articulate. Just keep learning. Get to know the difference between public and private. You could put all the affidavits that you want in if you're using Federal Reserve notes. And they can prove it. If they can prove that you just bought something with those Federal Reserve notes, those are private commercial scripts. They don't belong to
private commercial scripts, and your acceptance of it acknowledges a relationship to a contractual.
And it grants jurisdiction under Article 1, Section 8, Clause 17, where they get the ability to create the tribunal is Article 1, Section 8, Clause 9. It gives the legislature the authority to create tribunals inferior to the Supreme Court. And they found the hole in Article 1, Section 8, Clause 3, the Commerce Clause. So, hasta luego, TJ. See you later.
Hey, point.
Everybody at ULL, love you. You guys are amazing. Appreciate you.
You bet. Thank you. Yeah, guys, it's just, and by the way, to the gentleman that was speaking earlier, we're not, I definitely don't want you to think I'm arguing against you. I'm just trying to point out how easily it is for them to ask questions that are going to nail that. And because they know what they're doing. And they know what they're doing with state citizens and sovereigns. They know what you are. They know what you're trying to, the point you're trying to make. And I have no problem with you trying to make it. I'm just trying to show you how easily they can pierce it and pull you into their trust. And you're assuming a benefit, and now you are in a trust, a new whole trust, a whole new contract. And I'm not trying to discourage anyone from doing status. We have a status approach to it, but we also realize it's just a matter of correcting a few contracts. You don't have to make it that complicated. If your stuff's properly in trust, they can't really get to it. But you have to do this in advance of the fire. You can't buy the insurance after the fire starts. So just know that it's hard to do. Somebody said can't raise their hand. Let me see. Yeah, I don't know what to tell you. There should be pretty easy to raise your hands. Let me look at a different view of the console here. Sometimes it doesn't show me your hands. If you're on dialing in, or if you're on the computer console, it's pretty easy. You just click the raise hand button. If you're dialing in, *6 I think brings you in, but Uh-oh, somebody's on one of those Mac computers. Let me get a different view here. Maybe I can see you. I see Peter. Is that you? I see that hand up. Yeah. I see a Peter with their hand up. I'm trying to unmute you now. It's not letting me do it.
Oh, okay. Can you hear me? I just unmuted.
Yeah, go ahead.
Okay. I just had a quick question about the how to win in court case versus the evidence and rules of procedures tab under the the members pages on the website. What's the difference between the information in both of those?
I don't know what you're exactly asking me. What's the difference between? Okay,
So
there's
when I go under member pages on the website and I scroll down a little bit, there's another section you could click on called evidence and rules of.
Okay, I'm clicking on that on screen so I can follow along. Yeah, I got some links to the Federal Rules of Evidence, Federal Rules of Procedures, U.S. courts websites, some of just the tools that you can use too. I'm going to get that ad out there. Okay, those are just an overview of this concept. There's a ton of information there about it.
Okay, so the course goes, the How to Win in Court course goes more in depth than what's on here?
Well, this is more reference material. It teaches you how to do stuff, how to approach the course, what, when to file certain types of motions, what do these motions mean. So it gets into it a bit more, yeah. This is more reference material that you can use to go, I have a lot of the Federal Rules of Evidence and Procedures here, but it doesn't tell you, hey, here's the process of a court case. In this type of case, what you could say, what kind of argument could you use. You may go to these references and copy and paste some of them, but no, it's not that course in terms of being the comprehensive understanding of here's the court process, here's what happens first, here's what happens second, and so forth. So it's a whole different view of how, like again, this is more reference material.
Okay. Okay, got it. Thank you.
Okay, that was it?
Yep, that's it.
Okay. Yeah, you'll just see it. Once you see it, it's a whole different angle of it. It's really speaking to it from what your attorney should be doing, their approach they should be doing, procedurally, what to do next, when to do it, when to file certain interrogatories or motions, how to understand how to use elements better. That it goes into much more depth than I can go into here. It's a good, 12 hours of pretty concentrated material. And you can actually take a test and get certified knowing the information. It'll help you actually do a better job in court. It's written by an attorney for non-attorneys to understand. So it's a point of view that you can't get very easily. Okay. I don't see any other hands raised. If you're having trouble raising your hand, you can put a chat message in the chat room right now. It's a fairly complete question, of course. Otherwise, I don't see other hands raised at the moment. Oh, here we go, a couple more. Shane, go ahead. Shane.
Oh, yeah.
Yeah. You there? Okay, you got a few more hands raised. Okay. Do some quick questions here. Are you done?
Yes.
Okay. It somehow popped you up again. Area code 4034, Lisa.
Hey, TJ. Got a quick question for you. I have a trial coming up next week, and actually it's a credit card, so I did the administrative process.
So hold, pause a second. A credit card suit against you, is that what this case is?
Yes, that's right. So I did the administrative process, including the estoppel letter, and then months after that was ignored, they brought suit. So my defense is that this was settled in the private, but I'm not sure if I should try to press for mediation, and if so, if I have to do that in court or go to the attorneys. I contacted the attorneys initially, and told them that I had already done this, and they ignored it.
Well, okay. First of all, never go to court until you've tried to mediate something, ever.
Okay.
Because the judge is going to say, have you tried to do this? And if you don't, he's going to hold that against you and say you're not even following God's rules. Matthew 18, verse 15, 16, and 17. Go look it up. Matthew 18, verse 15, 16, and 17. That is the most fundamental rule of going to court. If you haven't done those things first, it's going to work against you. So, the answer is, verse 16, Matthew 18, verse 16, will tell you, the first one is go to your brother and try to work it out. So you've done some administrative challenges and that sort of thing. They've not spoken to you, just as that verse says. Then go to bring a second witness. The second witness is mediation. When it comes to contract law and money cases, they can probably get the court convinced that you owe them money. As hard as you can try, that's very hard to do. So if they will say, hey, how much is this case worth, by the way? What are they claiming?
They're claiming, with penalties and interest, they're claiming around $12,000.
Okay, but how much was the actual account?
I'm not sure, maybe 10.
Huh?
Maybe
the actual
10.
Principal maybe borrowed was 10?
Yeah, well, I don't know, but interest is outrageous, so I'm not sure.
Okay. But, okay, now the other question I have is, so I'm trying to just get you to back down on some facts that they're going to go off of. You're saying they can't prove contract. Who's suing you? Is it a law firm?
No, it's Chase.
But is it a law firm representing Chase?
Yes.
Okay. It's still probably a third-party debt collector. In most cases, it still is. Once it goes to a lawsuit, they turn it over to a debt collector. They sold it. So you might want to, if you talk to them, say, well, how much did you actually pay for this? Are you a third-party debt collector, or are you actually in contract with Chase? If you're in contract with Chase, show me the contract. And then show me the contract I have with you. See, these are the real questions, meaty questions. And they say, if they lie to you and say, no, we are representing Chase, we're on retainer, that's different than, oh, well, we bought the debt, we're really suing on our own behalf. Get them to commit that would be getting them to admit to a fraud by even answering. But say, I just want to know, did you buy this debt, or do you actually represent Chase? Let me see your contract with Chase if you say you are.
Well, what if they just ignore me like they have with the other things I've asked?
Well, no, just say, well then, how do I negotiate with you if you want to tell me who you are? Do we have a contract? Show me the contract that you and I have. I'm willing to talk to you. I just need to know this going in. And if you go to a mediation, these are the same kind of questions you'll be asking. Look, I'm not trying to not pay here, sir. I'm actually willing to work this out if we have to, but I need to see the documentation. Who's going to swear to this contract? Who's going to be the witness if we go to court that saw that he signed the contract, or that you are in fact Chase, or you are just a third-party debt collector? I need to know this so I know who I'm dealing with. I just want to know. Then we can talk about if there are numbers, if there's a contract. First, you're trying to determine who is the contract with, who are you even talking to. The attorneys say they represent all the time, but they don't. They're in their line. That's against even their own bar, agreement. So you first want to find out if they're lying by asking a few good questions, and then say, okay, look, if you were to make me an offer, what's the best you can do? And see what they say. And as I teach everybody in my negotiating, I just gave you the first one. I didn't say, I'll offer you 5. I didn't say that. I said, now, if you were to make an offer, what's the best you can do? If you were to make me an offer, what's the best you can do? Number one, if you, first of all, prove to me there's a contract. But then after that, if you can make me an offer, what's the best you can do? What I'm doing is I'm setting up leverage for the discussion. Sometimes it's better just to figure it out and get out of these, because if they win a judgment, then they can come after you for the full amount. So then the second question is, no matter what they say, let's say they say $5,000, you're like, oh man, I'd do that all day long. Never accept the offer. Scratch your head, look at the ceiling and say, is that really the best you can do? You've got to practice saying it that way. Your emotion will make all the difference in how they respond. And then they'll go, well, okay, we can go to 4, or whatever. If you get more, if you get it down to where you can swallow the deal, and you can get a little bit more, then go, it's only words. It's just a question. They can't hurt you for asking a question. There's no reason to be nervous about it. You're just using a strategy in terms of how you ask for, how you negotiate. If they say, well, we'll do it for 4, I said, and if you do it for, and last thing out, that's my final condition, so I've done 2, 3 swings. What's your best offer? Is that really your best offer? Then if I accept that, we also get this all removed off my credit. You don't bring that up till they've already pretty much come to a number. Now, if you get it reduced down to where you can actually afford it and you get it off your credit, would that be a pretty good situation for you?
Yeah, unless they wanted it all up front.
Well, they're going to say they're going to want it. They probably do to get it settled. But anyway, you know whatever circumstances you have. But that sometimes you have to go to your brother and work it out, bring a mediation, which is what you're talking about doing, and then go to court. Because if you go to court, you'll probably lose.
So the mediation, is that something I request of the attorney's end?
Well, I don't know what the procedures are. This is why you have to go to the court's rules of procedures. And also the contract itself may have a mediation contract in it. I don't know. If you just talk to them first and say, look, before we have to go to mediation, let me just ask you a few questions, and you start asking the questions like we've been discussing.
Okay.
Hey, Shane, you turn off your camera. Shane, you got your camera on, and I don't know what you're doing there, but we're looking at something that... Anyway, so that's how I'd approach it.
Okay, and since it's coming up quickly, I just need to go to them and ask them for mediation, basically?
No, I didn't say that. I said, talk to them and say, well, if we were to work out something, all I'm going to ask you for is this. I need to know if you represent Chase and if you'll send me the contract, or if you bought the debt, I need to see that contract. What you're getting at is if they bought it for pennies on the dollar, offer them that. But then the second thing is, well, if we need to go to mediation, which maybe we don't need to, if we can work it out amongst ourselves, you're going to do the exact same thing at mediation. You're going to say, well, I asked you for the contract. I need to know who I'm talking to. I need to know what capacity you are with them, and I need to see the contract you have with them. Or if you purchase the debt, I need to see that. I need to know who I have a contract with. And then we get around to numbers after you do that. See, I'm holding back a little bit. I'm willing to move forward, but I'm holding back a little. And I say, well, if we were to work out a number, I'm telling you the same thing again. I'm going to be a broken record. There's nothing new here. What would be the best you can do? But I would don't be too quick to office till you get this contract thing out of the way. Now, is that the best you can do? Is that really the best you can do? And if I do accept that, will you also agree to remove it off my credit?
Mm-hmm.
And can I make it in 2 and then leave it till the very, very end and say, no, listen, right now I can't pay the whole amount. If I can pay you in 2 payments, will you accept that? Whatever, they're going to want it pretty quick to take that kind of deal.
Mm-hmm.
So that's what to expect. That's how to negotiate your way down privately. This is all private because you're not in court. And you should avoid court if you can. Hopefully you create some equity, some leverage with your administrative process. That's the point of the administrative process, is to create leverage. And
right.
then
and I went
make
to
them prove
them,
a contract.
I went to them before. Yeah, I went to them before the initial hearing and gave them all that information. And
you gave them what information?
Well, I gave him the information that this was already resolved in the private, and I
Oh, yeah, but you did resolve it.
everything I did. But they, nothing. So if they refuse to show me the contract, is there anything I can do with that section?
Well, you can say, well, if you can't prove that we have a contract, then I'm going to have to sue you. Go to small claims court and sue them for making a false claim against you. Don't just make sure you keep it under the small claim limit, the amount you're claiming. But that's you can go there if you want. I don't recommend getting into a suit with them. If you can, just get them to settle it. But you could say, well, okay, I'm going to sue you for making a false claim against me. Sometimes that's enough to get them to go away, especially if they're a third-party debt collector. They can just drop it instantly.
Mm-hmm.
But yeah, that's a possible angle. You can preserve that. And you're playing cards or you're playing poker. You're asking questions at the right time. Knowing what you're willing to do, if you can settle it and work it out, that's your best chance of getting what you want. Everybody wants everything. But I also say pigs get fed and hogs get slaughtered. So be careful.
Would you have to go ahead and go to the court hearing then, even if we...
No, if you work it out, you can write a contract and they'll drop their case.
Okay. Okay. Gotcha. All right. Thank you
You
so
don't.
much.
Yeah, they can just dismiss the case anytime they want. But they're going to want everything settled and done.
Right. Okay. Thanks a lot.
Okay. Hope that helped. Give you some perspective at least. All right. Matthew is next. And not the verse 18, chapters 15 and 16, 17, Matthew. Just a guy named Matthew.
Yeah, that's great. You hear me okay?
Yeah.
Awesome. Yeah, thank you for that. Yeah, I'm that Matthew 15, walk with your adversary on your way to the court and agree with him on the way, lest you be knocked up in prison, et cetera, et cetera. I'm learning that in real life over the last 6-7 months. It's a process that is priceless, if you will.
It is the answer to so many questions.
It is.
And then you have to put, because the law has it written in.
Yeah, that's one of the best things I've probably learned over the last 6-7 months of going through materials you are a lot and listening to the conference calls and whatnot. I had 2 quick questions for you tonight. I began to look at your materials and study federal rules of evidence and whatnot halfway through a real small claims case, and it's only $1,000. It's not a big deal. And
good way to learn.
What I liked about it was it gave me the opportunity to research and use the tools that are available in real life. So, if and when down the road that comes to, a bigger deal, I'll have at least some kind of understanding and learning on how things work, even though I'm getting railroaded. I had a small claims case when they were brought against me for cutting down some trees that they were on this property. I know they weren't because I have my property surveyed first, so I know they weren't. But the case they brought, I didn't understand the federal rules of evidence and authenticated evidence and the processes that I should have been looking for defects. And in retrospect, I see them now. Just recently, I had an appeal, and I was actually late to court because I thought we were still doing Zoom hearings, and I didn't realize. But up to that point, it had been Zoom hearings, and they had changed it to an in-court appearance. So I screwed up, and I was late. I actually called the court, and then I had to rush down there. So I pissed the judge off by being late. That's kind of where I lost my appeal. Yeah, she asked me, said, you want to sit the jury? Because it was a jury hearing. I didn't want to do it for the judge because the judge had already railroaded me. So I said, I better do it before my peers and bring up things of laws and fact for an appeal. Abuse of process, no authenticated evidence, admission of just hearsay and speculation and no facts.
Good. Yeah.
Unfortunately, the funny thing was after I agreed to go to the appeal with the judge on that day, thinking I'd try to gain some favor and say, okay, let's settle this today. When she called me, she brought the parties forward. She initially said, well, I'm going to retry the case. And the appeals thing went right out the window. And so I said to her, I said, I took the judge, I said, excuse me, I was prepared, for an appeals stage to deal on facts of law and evidence. Not this, what is it? Facts and law. And she agreed, but I'm still going to retry the case. And that kind of threw me out the window, guys. I want to just specifically not argue those points, but I already had those specific things from going through, and I listened to
And you lost the case originally?
Yeah, she ruled against me.
So she was giving you the opportunity to retry the case?
I didn't want to retry it. All I wanted was the...
I get it. And maybe she was giving you a doorway, too. Why would she do that?
That's this.
Otherwise.
I think it's because of the fact that I put in my appeal that there was no authenticated evidence.
Well, but see, sometimes the judge would rather retry the case and not have his reputation damaged by going to appeal. So I've had one judge in one case, and unfortunately the guy didn't follow through with it, and I said, man, he just gave you the doorway. Sometimes they do. You just have to be paying attention. But he says, do you want me to put a motion in for, I forgot what rule, anyway, it had to do with effective evidence. He said, do you want me to put a Rule 12 or whatever it was motion in for you? And the judge was literally offering to put that in, and then he would have to reconsider that on the procedures. And I thought he'd handed him the gold ticket, and he kind of blew it. I was like, he just told you that you've cited that there was defective evidence. He agreed by asking if he would assist you in putting in the motion. You could have done it yourself. And that motion would have been given him the doorway to dismiss it. He doesn't want to go to appeals and lose.
There are certain instances on this, like this was just completely. For instance, the property that the damage the court happened on was in this other party's possession, and then when they realized they had legal exposure because the tenant was just acting criminal in nature, they took the property and put it into a trust. And one of the things I brought up in court when the authenticated evidence was this case is being brought forward by the individual and not the trust. And regardless if they're a trustee or not, this case would still have to be brought up. The case would have to be brought forward by the trust because the trust owns the property. It's something that I thought was simple, but they still. That was just one of the points that should have been like a slam dunk. How can you bring a case if you're not the actual aggrieved party? But
right.
So at this point, they brought rules, for like $1,000. So I have a payment hearing coming up, and the question I have for you concerned is I'm in the equity course, and we're only just getting started. So there's still some time for us to understand, and it's kind of early for me to understand whether I should go the equity route or just for practical purposes, use that as an end game.
Well, hang on a second. You're saying this is the case where you're the plaintiff, right?
No, I'm the defendant.
Oh, okay. I thought you said you were doing a small claim suit. I don't know if you were talking about that.
They put a claim against me, even though I dispelled their claim.
It'll be very hard for you to switch gears after doing all you've done to argue, because the first rule of equity is no argument at all, or it kills
That's what I was thinking. So my other
now you could rescind. But it's really hard to rescind the stuff in the middle of a case. Just
better for me
not going to go well.
Send a motion because I know. Unfortunately, it's too late, but it's never too late to learn. Now I understand the court. I mean, the judge is more than just a referee, and it's my job to move the court and make motions so I can get them.
And you can't do any of that using equity. You can't move the court.
Exactly.
You're actually acknowledging the court's jurisdiction, which is fine. Because what you're asking the court to do is make a ruling. You can't challenge jurisdiction and ask the court to dismiss. Because that's a ruling.
No, it is. It is. When I'm in equity, I mean, down the road when the judgment just gets set and you owe a certain amount of dollars, et cetera, and you have to pay this and whatnot. That's more of the paper commercial aspect of it. But what the question I have for you is. If I should probably do first is file a motion to vacate based on judgment based on abuse of process, which I could prove, and the second would be a motion to vacate on lack of authenticated evidence. No,
that's always one of the best ones. if there's lack of authenticated evidence, because that's an appealable issue.
Right.
And courts don't like appealable issues. They don't like to know that, hey, they could overrule me. Maybe that's why I think he wants to retry it. You might have a good point.
That was one of the points I put in my letter for the appeal, was there's lack of authenticated evidence. And I told them, and I showed them in court. I mean, they produced
So they say, Your Honor, I'll accept your offer to retry this, so long as I'm not waiving my right to appeal on this point. He'll know what you're saying, and maybe he'll just simply rule, hey, you know what? Good point. We didn't see this evidentiary rule, so now I have to reconsider and rule in your favor. I think he's giving you a doorway.
Well, when they originally, the same day that I was supposed to file I showed up for the appeal, and I was late, and I kind of screwed myself on that when the judge said, well, we could try before do a jury, we could forget the jury trial and try here before the judge and do a bench trial, if you will. That was the day I went ahead with this, and still listed the lack of authenticated evidence and the abusive process. And a letter ruling, well, it just said we still fine for the plaintiff. There was no explanation or whatnot, so it's already past that.
Okay.
So the only other thing I
thought
could
you
do.
were saying you're still offering it.
No, I wish I was. Then I wouldn't be calling you right now.
Well, then you might have to write this one off because you're pretty far out afterwards. I mean, you can do your appeal and try that, I guess, but
Just the
motion. If you miss a hearing, I can't tell you how to fix that.
Oh, no, I didn't actually miss the hearing. I was late to it because it was supposed to be Zoom. I thought it was Zoom. I didn't realize until afterwards.
Right,
I was 15, 20 minutes late, which is not the end of the world, but enough to piss them off, I think. So.
No, when it comes to whether you should appear, I get messages all the time. I didn't appear. I wasn't on time all the time. What do I do now? I said, turn back the clock and appear on time, because that's what we recommend. After that, you just screwed yourself. You accepted the judgment. That's a default.
Right.
You waive all your rights.
No, I did appear. I was there. I definitely was there.
Yeah, I get it. I mean, I was just saying, as a teachable moment for everybody else.
Definitely.
Get it right.
Definitely. Last quick question. I have a.
Didn't you say your first question was a quick question?
Yeah. This one is very quick, though. I promise. I got an SPA notice saying I owe money, which is fine. It's only a small amount. I put it off. But when I went to the website, I noticed that one of their on my account, it says charged off. But I got a letter sitting here saying, you owe a certain amount of money, and you don't do X, Y, Z and pay this, and we're gonna, handcuff you and throw you into the ocean with cement shoes and whatnot. If it specifically says on my account, there's already been charged off on the SBA website under my account. Should I still make payments, or should I? Because will that reverse the charge off, or what's going on here? Should I?
I'd ask them that question. I mean, I'm confused. Is it? You say it's charged off, but you say I still need to pay you. So what am I paying, or who am I paying, and is this going to reduce or going to get the charge off my account? Yeah. What's the benefit for me to pay it then?
That's probably something I should probably just kind of lag a little bit. I'll probably send them a note.
I mean, it just depends on how they handle charge-offs.
Yeah.
There's no one. I mean, if it's a credit card company, you can say, well, look, if I do work this out with you and I get you a payment, it's going to a third-party debt collector. We already sold it, which is most times the case. Okay, well, if I pay it, or you negotiate with the third-party debt collector, will you get this removed and put that in writing? At least get them to get something back in exchange for working it out.
Right. All right, thanks so much, T. Jeff. See you guys tomorrow.